Good afternoon, everyone. Welcome to the City at Madeira Beach Code Enforcement Hearing. My name is Bart Valdez, and I'm the appointed special magistrate to hear today's cases. I'm a practicing attorney and have been a member of the Florida Bar for over 20 years. I've been appointed to this position in accordance and with the authority set forth in Chapter 162 Florida statutes. It is my role to fairly and objectively review the matters presented. As such, I would like to advise you of certain matters related to today's proceedings. Today's matters will be heard in the order that they appear on the agenda. Every effort will be made to hear all persons having relevant evidence, argument, or comments to offer related to the specific case that is being heard. If you wish to speak today, it is necessary that you be sworn in by the city attorney in just a few moments. In all cases, since the city has the burden of proof, the city will present its case first. The respondent or property owner then will be given the opportunity to refute the city's allegations. Formal rules of evidence do not apply to this proceeding. However, I will exert every effort to ensure that fundamental fairness is afforded to all parties. After hearing all relevant evidence, I will issue an order. The order will be reduced to writing, and you will be provided with a copy by mail. Therefore, please make sure that we have your current address. Additionally, you are advised that I do not have the authority to grant you a variance, permit, or special exception of any kind. My role is solely to determine whether a city code has been violated and to provide you a reasonable time to correct the violation by whatever means is available to you. Please be advised that you may be subject to a fine and a lien may be recorded on your property if the violation is not corrected by the compliance deadline. If you wish to present any information to me today, it is necessary that you swear or affirm that you will tell the truth. Therefore, at this time, the city attorney will swear in all witnesses.
Anyone that's going to speak, if you could stand up, raise your right hand, and be sworn under oath. You swear that the testimony you're about to give today is going to be the truth, the whole truth, and nothing but the truth?
I do.
Okay, thank you.
All right, the first case on the agenda today is case number CE-24-0023 for the property located at 480 129th Avenue East. Is the city ready to proceed?
Yes, I am.
Go ahead, Mr. Trask.
First of all, I'd like you to take judicial notice of pages 3 through 5 in the packet. This is the findings of fact, conclusions of law, and order imposing fine that you as a special magistrate entered in the month of January last month. It was actually signed on February the 6th of 2024. The first witness, or the witness I'm going to call on this particular case, is Deputy Snyder. Deputy Snyder, can you tell us what your job is, what your occupation, your responsibilities here at the city?
My name is Corey Snyder. I'm a Pinellas County Sheriff's Deputy. I provide community policing and code enforcement for the City of Madeira Beach. I've been in the City of Madeira Beach since 2015 and in a code enforcement capacity since 2017.
Thank you. Are you familiar with this property that's located at 480 129th Avenue East?
Yes, I am.
Okay. And who's the owner of that property, and how do you know that?
One Gabriel D. Candido through the Pinellas County property appraisers and the Pinellas County tax assessors information, public information.
Okay. On this particular property, is this a proactive case, or is this as a result of a complaint?
This is from a complaint.
Okay. And what was the complaint that you received on this property?
This property was identified on a previous code case as two different properties having weekend rental activity from a neighboring resident, both 441 and 480 129th Avenue East.
Okay. And did you go out to the property to inspect it to determine whether or not that there was actual violation of the short-term rental prohibition?
Yes. On February 9th, I went to 480 and 129th Avenue, where I spoke to a David Allen, who advised me he rented the property for 2 months from January 3rd through the end of February.
Okay. When you went out to the property, did you happen to have your body camera video on?
Yes, I did.
Okay. And do you have that videotape today?
Yes, I do.
Okay. Can you go ahead and play that? Approximately how long is the of this particular video?
It's about a minute and a half.
Okay.
Sorry to bother you. I'm Deputy Snyder. I work for the city's community policing and code enforcement. I have to do a real 2-minute compliance check. Just
Do your thing.
just from right here. Here's my card. Just a couple questions. How long are you running for?
Another 2 weeks. We've been here since like January 2nd, so it was a 2-month lease.
2 months. Do you remember how much?
I got a wife. She handles all that.
So checked in January
Second, third.
3rd. Are you leaving?
I can back it up here, sir.
We did take
Yeah, let me back it up
a
here.
trip, so I got a wife. She handles all that.
3rd
Right about there.
through.
It's the communication from the computer to the
We might
kiosk,
take,
sir.
have a lease for 2 months. but
Gotcha.
We'll be,
The audience needs to see it too. No?
Let me try to back it up so we can fill in the blanks here.
lease.
2 months. Do you remember how much you paid for the 2-month period there?
I got a wife. She handles all that.
So checked in January.
The end of the month.
End of the month. Okay, so 2 months.
But we did take off for a few weeks down to Key West.
Okay.
You know, we have a lease.
And rough guess, 2,000 a month, 3.
It's still playing on my
Yeah. Okay. Very good. And then your name.
passing through here.
Have a good day. Enjoy your stay.
Can you just show the, instead of-
I can show it on the laptop itself. I can do both. If I disconnect the HDMI, I can let it play so that I can do it both directions here. I can do it once and I can do it again, so both the audience and
all right, why don't we go ahead and do that, so it stops cutting out. So we'll show the special magistrate first, and then the property owner. Put the microphone down in front of it.
So we have a lease for 2 months.
Gotcha.
But we'll be in and out.
Very good. And then rough guess, 2,000 a month, 3,000 a month.
That's not.
Yeah. Okay. Very good. And then your name.
My name's Dave. David Allen.
Sir, have a good day. Enjoy your stay. It's warming up a little bit now, so.
Sure.
There's a white car and then there's a black car. Is there
Yes.
somebody else?
We have guests.
Oh, very good. Enjoy. Thank you, sir. Appreciate it.
Okay, if you could turn it around. Do you need to see that? You're saying yes, you're saying no. Let's go ahead and turn it around and show it to him again.
Sorry to bother you. I'm Deputy Snyder. I work for the city's community policing and code enforcement. I have to do a real 2-minute compliance check. Just
Do your thing.
just from right here. Here's my card. Just a couple questions. Are you the homeowner?
No.
Are you renting?
Yes.
How long are you renting for?
Another 2 weeks. We've been here since like January 2nd, so it was a 2-month lease.
2 months. Do you remember how much you paid for the 2-month period there?
I got a wife. She handles all that.
So checked in January
Second, third.
3rd
Right about there.
through, when are you leaving?
The end of the month.
End of the month. Okay, so 2
But
months.
we did take off for a few weeks down to Key West.
Okay.
And stuff. We might take another trip, so we have a lease for 2 months.
Gotcha.
But we'll be in and out.
Very good. And then rough guess, 2,000 a month, 3,000 a month?
That's not.
Yeah, okay, very good. And then your name?
My name's Dave. David Allen.
Sir, have a good day. Enjoy your stay. It's warming up a little bit now, so.
Sure.
There's some, a white car and there's a black car. Is there
Yeah.
somebody else?
We have guests.
Oh, very good. Enjoy. Thank you, sir. Appreciate it.
Okay, after this initial contact with the renter, did you have a subsequent contact with the renter?
Actually, as I drove away, there was a woman walking down the street. I said, you don't happen to be Mr. Allen's wife? And then I provided my card again with my phone number, and she was going to get back to me. So that's actually captured on body camera also. So I can play that if you'd like. It was just I gave my information, and she could not give me the amount she was going to. And I had a subsequent phone call from Mr. Allen that happened the next day, and that was captured on body camera.
Okay, why don't we go ahead and play the phone call the next
Phone call.
day?
Okay.
Well, this is a phone call. You really don't need to show the video, do you? You just need
It's
to,
just, it's a transcript of my cell phone, which was captured on my body cam.
okay.
Audio. Maybe. I still have it saved on my phone. For some reason, I'm having issues with it.
You want to play it off your phone then?
I have it on my phone available.
Okay.
I mean, this was a video capture of the call. I don't know why it's not.
Well, why don't you play the voicemail for the special magistrate?
I apologize. It was dated February 10th at 11:18 a.m. I had a missed call with a voicemail.
Hello, Deputy Corey. This is David Allen. You had stopped by a rental house here at the address is 480 129th East Avenue East. You were asking my wife and myself about how much we paid, and it was $15,000 for 2 months, starting January 2nd through February. So, if you got any questions, you can give me a call back, 248-255-2003. Thanks.
All right, thank you. I'd like to go through some of the documents that were created as a result of this investigation. First of all, What is the actual code violation that is being cited in this particular case?
This is Madeira Beach, Section 110-201, R2 violations.
Okay, and what does that provide?
The R2 violation states the R2 low-density multifamily residential district provides for low-density multifamily residential, correlates with the residential medium RM category of the countywide plan, and which does allow for a variety of dwelling types. Any use which is not specifically identified as a permitted use, accessory use, or special exception use is a prohibited use. Prohibited uses shall include, but are not limited to, short-term rentals of a housing unit. As used in this division, the term short-term rental shall mean any rental of a dwelling unit or portion thereof for less than a 3-month period.
Okay. So starting back in the packet of information that has been provided in the agenda, I'd like to start with page number 6. If you could take a look at that, and we're going to go through these page by page for you to explain what these documents are. So, page 6.
Hello, Deputy Corey. This is David Allen.
Oh, it actually played.
I think it caught up, so my computer caught up to it and finally buffered.
Yes, go ahead and shut it off.
I do have it available on video if needed. I heard it. Okay.
Okay, we're again back to page 6, actually 6 through 9, if you can explain what those, or 10, what those documents are.
Page 6 is a screen capture of the Pinellas County Property Appraisers website, which shows the site address 480 129th Avenue East as owner, as belonging to one Gabriel A. DeCandido and Gabriel DeCandido Trust.
Okay, and that's pages 6 through 10?
Let's see, 7 is a continuation of it with a map view and other information such as parcel number 8. Page 8 has some links to the tax appraisers. Let's see here. Sell date, just miscellaneous information on the property appraiser's website.
So that goes 6 through page 10, correct?
That's correct.
All right. And starting at page 11, if you can explain that.
Page 11 is a screen capture of the Pinellas County tax collector showing that one Gabriel DeCandido is the owner of 480 129th Avenue East, Madeira Beach, Florida.
Okay, and that's pages 11 and 12 of the packet?
That's correct.
Okay. Did you issue a notice of violation in this case?
Yes, I did.
Is that the notice of violation on page 13?
Yes, it is.
Okay, and when was that issued?
This was mailed on February 9th, 2024.
And does that reflect the code section that you were reading from earlier today?
Yes, it does.
Okay. And how was this particular notice of violation sent?
Both certified and regular mail.
Okay. And does the next couple of pages reflect a photograph of the letter that was sent on the 9th day of February?
Yes, it does.
Okay. Did you receive the green card back?
I received one of them back. Yes, let's see here, 1667. Yes, I have it. It was signed and I received it back.
Okay, I'll go ahead and take that. We're going to tender that into evidence. Okay, and if you could turn to page 16, are these your notes reflecting your conversations with the renter?
Yes, it is.
What else does this reflect?
It shows the case notes. This is using the GoGov system. It starts from the type of issue. It's a zoning issue, who initiated it, myself, the dates, the address, the parcel number, the owner on file, his physical address in Seminole, and then the dates which I had inspected the property and identified a short-term rental violation, sending out a letter, the corresponding letter, the contact by phone from Mr. Allen, and then the documentation of the mailing of the special magistrate paperwork.
Okay. So if you could turn to page 17, It's titled at the top, Special Magistrate Notice of Hearing for Today. Did you also send that by regular and certified mail to the property owner?
Yes, I did.
Okay, and what date did you send that?
This was on the 16th day of February, 2024.
Okay. And did you receive the green card back for that one?
I have not yet.
Okay. And did you issue an affidavit of service as reflected on page 18?
Yes, I did.
Okay, and what does that document provide?
This was that on the 16th of February, 2024, I mailed a copy of the notice of hearing. I mailed a copy of the statement of violation and the notice of special magistrate hearing, statement of violation, and request for hearing. Let's see, notice of hearing, affidavit of service, statement of violation, all three of those.
Okay, and those are reflected on pages 18 and 19?
That's correct.
All right, and what about page 20 of the document, or the agenda packet? What does that reflect? Just another copy?
20 is the notice of violation that was mailed out on the February 9th.
All right. And then on pages, which I can't tell, looks like pages 21 and 22, the last several pages of photographs, if you can explain what they are?
We've got several photographs here that, okay, so is this different than one I have?
No?
Okay, so we have just photographs of the mailings for the special magistrate paperwork,
Okay.
both sides. And it's of the certified copy that was mailed.
All right. Was the property also posted?
Yes, it was.
And is that the last photograph?
Yes, it is. That is one of the last, and then of the overall property from the street with the posting.
All right. So the city is bringing this forward as a repeat violation, is that correct?
Yes, it is.
Okay, and how many times has Mr. DeCandito been found in violation of this short-term rental ordinance in Madeira Beach?
This is one for R2 violation, one for R1 violation. This will be the third.
Okay? And this is for an R2 violation?
Will be the second R2 violation.
Okay. Today being February the 26th, is the renter still in this property?
As of the date of my email, or the voicemail, they were still in there, and they were paid through the end of February.
Okay. All right. All right, I don't have any other questions for you at this time. I would tender into evidence. First of all, I asked again that you take judicial notice of the previous special magistrate order dated February the 6th, and tender into evidence pages 6 through, looks like 24, I think it is. And also note that the second page of the back side of the notice of hearing is on the dais, as well as the second page of the statement of violation. This was a two-sided document. It didn't make it into the packet, but I did provide it to you on the dais. Ask that they be received into evidence.
All right, Mr. Trask, let me do a little housekeeping, make sure I've got everything right. I'll go ahead and accept and take judicial notice of pages 3, 4, and 5, which were my prior order for the same respondent in regard to a different property in Madeira Beach. I'll go ahead and accept into evidence as exhibit number 1 the portions of the agenda package, which are pages 16 through 24.
6.
Excuse me, 6 through 24. I'll go ahead and accept into evidence, because this is the way it came in, exhibit number 2, which is a return receipt for the certified mail. It appears to be signed by Mr. DeCandito. I'll then accept into evidence as exhibit number 3, the special magistrate notice of hearing. That is a 2-page document dated February 16th, 2024. And then as exhibit number 4 will be the special magistrate statement of violation / request for hearing that was signed by Deputy Snyder.
And I'd also move it into evidence the audio tape of the voicemail and also the videotape of the body camera.
All right, I'll go ahead and accept into evidence both the videotape and the audio recording. All right, anything else with this witness before I turn to the respondent for any cross-examination?
No.
Deputy Snyder, do you have any proposal in what the city is looking for in the way of a fine here or corrective action?
Sir, I think my conversation with the city, we're looking for $300 a day for daily fine.
And the compliance would be to cease short-term rentals, correct?
That's correct.
But this being a repeat violation, we're looking for the fine to start as of February 1st and run through February 29th. Even though that this renter would have been in for 59 days, we're only asking for 29 days worth of violation because the case that was heard last month gave him until January 30th to bring it into compliance, so we don't think that it's fair to fine back to January 2nd. So we're only asking for February 1st through February 29th at $300 a day.
All right, thank you, Mr. Trask. I'm going to give you, of course, a last chance before everything's done if you want to change that recommendation at all. All right, is anyone here on behalf of the homeowner or the respondent? All right, who wants to come up? This is your opportunity to cross-examine Deputy Snyder to ask him any questions. So who would like to come up and do that?
Gabriel DiCandido, I'm the homeowner.
All right.
Bring the microphone down in front of you, we can all hear you.
All right, Mr. DiCandido, you may recall from the last time we had this hearing, I'm going to give you a chance in just a few minutes to explain to me whatever you want to explain to me. This portion of the hearing is just for you to ask Deputy Snyder questions based on his testimony. Do you have questions for Deputy Snyder?
Yes.
Go ahead, sir.
What is the reason for asking the amount of rent that was paid?
It has been the practice to identify what site was used to rent the property, the dollar amount that was rented, the length of time, and then the dollar amount spent. It's our standard questions that we try to ask on every short-term rental investigation.
Is that related to what we're talking about now?
I don't understand the question, sir.
How is it related to the fact that there's been a violation of your code, code 2 in regard to short-term rental? How is the amount that it was paid related to the short-term rental?
I think it's significant in these cases because someone could charge a lot of money and be found in violation and still profit from the amount that they're charging. So I think it's significant to identify how much someone is paying in these areas and for the length of time. It's extremely significant in these cases, in my opinion.
And then, is it not true that in this town there are separate I have 3 different properties. Each one is a separate particular property and has a different setup with the town, in that I have to pay specifically each month or each year for each particular property because they are not considered to be together, as you're indicating. Unit 441 and 480 are. They are completely separate entities per the town ordinance.
Question, sir?
Yes, the question is, do you not see that as that the 3 properties are separate?
So in this instance, at the last hearing, you identified that you had a neighboring property up the street at 480 when we were discussing 441, 129th.
But the properties are separate according to, why then is it that I pay separate fees to the town for each different property and they each have their own separate code number?
The code applies to the zoning district that the houses are located in. You pay a separate business tax for each location that you have a rental unit in the city.
But each one is dealt with separately. They're not related regardless of where they are in the town. So if they are separate, why is it that you're trying to join them together as a repeat violation?
When you were found in violation for 441 129th, you acknowledged that you had another house within that same zone. This would be a repeat violation for the code that you claimed you didn't know existed, or I can't remember what your explanation was. Similar zone property, same block, you were made aware, you were given a time to come into compliance for that zone.
Does the town, then why is it that the town charges separately for each individual property regardless of zone?
I don't know what your question is. Charges what?
That my business tax, which I pay on each property, is separate. The two are not together. Therefore, they are considered, why do you not consider them to be separate as the town does from one to the other?
The properties are separate, but the violation is a continuation of the practice from one address to the other in the same zone.
How can you join two violations when they're at separate entities? Does the zoning create contiguity?
Sir, I understand what you're asking, and I understand what Deputy Snyder is telling you. So why don't you move on to your next line of questioning, because it's getting repetitive, and
Okay.
I understand why you're
You
asking those
understand what I'm
questions,
asking.
and I understand Deputy Snyder's answers to those
Okay.
questions. So why don't you move on?
I will have further to say after
All right, go ahead and
testimony. I have,
don't go far, because I don't know if Mr. Trask is calling anyone else. So, Mr. Trask, any other witnesses?
No other witnesses.
but I have my realtor who I have engaged as far as this is concerned to come next.
Okay, great. Just give me 1 second. Want to know if Mr. Trask has any other questions of Deputy Snyder based upon your cross-examination.
No questions.
I'll come back to you in a few minutes, Mr. Trask. Okay, Mr. DeCandido, this is your opportunity in the hearing for you to call any witnesses, for you to tell me anything you want to tell me, so go ahead.
Okay. First of all, I want to state that I am elderly, retired, and am not actively in business, and that I've hired a realtor to take care of the properties for me, and we all understand the business of real estate, and I have brought her to explain the reasons for the presence of the current tenant there. I am not the realtor. I may be the homeowner, but I am paying the taxes and am strictly elderly and retired. What more can I tell you? And then I'll have my realtor come by and explain the reasons for some of the events that have occurred here.
All right, before you leave the stand, Mr. Trask has the right to ask you questions based upon what you just told me. Mr. Trask, do you have any questions?
Just a
Mr.
few
DeCandido?
questions. Mr. DeCandido, if my memory serves me right, you have approximately 10 rental properties in Pinellas County, is that correct?
It's true.
Okay. And does your realtor manage every one of those properties, or do you manage some of them?
I have different realtors for different properties, and a couple which are self-governing, I take care of myself.
Okay, and so how many of them do you manage yourself?
Well, some of the properties don't even require management. You just pay the taxes on them. So it's a difficult question to answer.
You have 10 properties, sir.
Yes.
How many
some
of them are you
do not
managing?
require management.
I understand,
That's what I'm
okay. And let's do it the opposite way then. How many properties do you have a realtor managed?
6 or 7.
Okay. So is it fair to say then the other 3 or 4 are being managed by you?
A couple of them are vacant land. So that's, if you consider that management, fine.
Okay, sir. And how long have you been, well, tell us how long you've owned these 10 properties in Pinellas County?
Years, except for the last 2 that we're dealing with now.
Okay, when you say years, can you tell
Maybe
us how long?
10, 12 years.
Okay, so before the realtors got involved, then you were managing them on your own, correct?
When I was more active and younger.
Okay, sir. All right, thank you. With regard to this particular property at 480 129th Avenue East, you don't disagree that you rented that property for less than 3 months, do you? For this particular violation?
I disagree that that was my intent. My intent was the opposite.
Okay, so let me just back up then. So Mr. Allen rented this property from you or your realtor on your behalf from January 2nd through February 29th, correct?
Correct.
Okay.
Well, not really. The question was whether he would extend it another month, and as it turns out, he decided not to extend another month.
But he paid you in advance for 2 months, correct?
I don't know. I leave that to the realtor.
Okay, I'll ask her then on that. And you heard Mr. Allen say that he paid $15,000 for those 2 months. Do you know whether or not that figure is accurate?
No.
All right. Thank you.
All right, Mr. DeCandido, let's hear from your realtor.
All right.
Good afternoon, ma'am. Before you start, will you just give us your name and what company you work with?
Lisa Erickson, Engel and Volkers,
And can you spell your last name for me, please?
Erickson.
All right. Ms. Erickson, what would you like to share with me about the violations that we're here on today?
Okay, so when we were here last month, I believe it was on the 22nd of January, I believe we were given 2 weeks at that time to remedy. I don't have my notes in front of me, but I think it was more than the end of the month because it was requiring quite a bit of maneuvering through Airbnb. So we might want to count the days on which that was to take place. However, since that time, we got into compliance, got all the licenses from the city issued, got DPBR licenses as requested and needed, no problem. We're set for inspections on these 2 properties in particular on Thursday to make sure that everything is kosher for the city as well as the fire department. I spoke to them. Secondarily, the people that we're referring to, they don't really pay in advance. They actually had 2 separate reservations for 2 different months, and they were going to extend. They decided not to do that. At the time we were here in January, they were legally here. They were in that property. And I cannot remove them without reason because they have paid at that point to Airbnb. Was it released to us? No. But they had paid, and I could not evict them. They were already in the house. I would have to go through a legal eviction process to get them out. However, all the other cancellations are done. Those were taken care of, and there was no other further activity in the other property as well as this one. So I'm asking for, I guess, acknowledgement that that was legally not even possible to do to take them out. But they are the last of the non-binding of the term limit there. I guess is that best I could put that. And they were, it's not to the 29th. I have a copy of their dates that they were here. It's to the 27th for their last reservation that they made. So it's not till the 29th. Just FYI.
Do you have that form you can show Mr. Trask, whatever
Yeah.
you're referring to?
Airbnb's reporting is horrible, so it's kind of kludgy, but I'll show you what I printed out for you. Would you like to I mean, I can't print out they wouldn't let me print out a prior completed booking, but I have the booking now where I can show you they actually did 2 different bookings, and they were going to add on this extra month. So do you want to see what I have to show you that?
Show it to Mr. Trask, and then let me see if he objects to me looking at it first, and then we'll go from there.
Okay. It's February, it's January. Oh, that's why we see it like that, okay. Why they did it like that, I don't really know, but that's the way that they booked it, so that they wanted 2 separate bookings. Maybe because they didn't want to pay the full boat in total at one time, because it does force that.
All right, Ms. Erickson, just so make sure I'm following this correctly, when the Allen family, or Mr. Allen or Mrs. Allen originally booked it, they booked it for 30 days, approximately in January, from, it looks like January 9th through the 31st in January, is that right?
They did it almost simultaneously because she was emailing me. Their intent was to book the 3rd month. They didn't do that. Why, I don't know. But if you add up those numbers, that would come to like $15,000 for 3 months.
Gotcha. All I'm saying is, it looks like for January, they booked from January 9th to January 31st, and then for February, they booked from February 3rd to February 27th. Am I reading this correctly?
Ish. There's probably some dates in between there that they booked interimly. I just pulled out the biggest months, but they've been in there since January 2nd, as he acknowledged.
Okay. Do you want me to include these in the record of the proceeding, or you want me to hand these back to you?
I'd rather keep those.
Okay. Then you can come get these, but I understand them. All right, Ms. Erickson, what else would you like to tell me in regard to this code violation proceeding?
Yeah, so I think I've stated the case that I legally couldn't extract them, but everything else is in compliance that you had asked for. And, you know, from a repeat offender, I think that's pretty harsh, because the Lillian Drive thing was quite some time ago. I don't know when that one was, but that was some time ago. This one over here at 441 we've remedied, and this one is the last of that. Everything else is converting into 3-month or longer at this point. So I'm asking for, I guess, your assistance in this, because we are definitely cooperating to remedy any issue that was relative to the prior realtor, where I had to spend hours and hours on the phone with Airbnb, canceling everything, which is done, and this tenant was already there, so I couldn't extract them.
All right. Thank you, ma'am. Don't go anywhere. Mr. Trask, you have cross-examination from Ms. Erickson?
Just a few questions. So with regard to the 2 reservations for 2 separate months, and you keep referring to them as 2 bookings, why is there a gap between January 31st and February 3rd?
They had a small gap there that they booked interimly, and I didn't pull that out, but they did, because he acknowledged he's been there since January. So they've been there. Their intent was to stay there for 3 months. Why they did it the way they did it, I don't really know.
Did you have a reservation for the 3rd month?
No, they said that they were going to book that because they booked one, then they booked the next, then they said we're going to book the next. They never did the 3rd.
Okay. So so the bottom line is he had one reservation for January, from January 9th, I think is what your paperwork says, through January 31st, even though they were in the building already by January 2nd or 3rd, correct? Okay. And then the next one, according to the paperwork that you have, would have started on February the 3rd, 3 days after the compliance date, or 10 days after the special magistrate hearing the last.
They were already
Let me finish
there.
my question. I understand. But the booking paperwork provided that their term was from February 3rd to February 27th.
I can get you another of the middle portion. I just did not bring that today because I know they were there and they acknowledged that they were there.
Okay, but the terms were for different periods of time. That's what I'm trying to get to. You don't disagree, then the last one was from February 3rd to February 27th, correct?
Per that booking, yes, but there was another booking because they've never left that property.
Well, there may have been interim bookings, but each booking
No, they
acts on
never
its
left
own,
the
correct?
property. Their items never left.
I've got that, but that's not what
Yeah.
the paperwork provides, correct?
Well, Airbnb is not great because it doesn't show you a holistic view. I'm showing you the main components that we're talking about for their quote-unquote monthly bookings, but there was no other person in there.
So the paperwork there also provides that for the month of February booking, it was $7,500. Did I get that correct?
I don't know what it says. What does it say there?
Well, you've got it in front of you,
Oh,
ma'am.
okay. You gave it back, that's right. No, 5,700.
For the month of February? Mm-hmm. What were the other totals that were added to it?
I don't have that in front of me because that's a past, it's a past closed out booking.
Okay, well,
Probably about the same.
okay, so it would have been about 5,700 for January and about 5,700 for February, correct?
Yeah, roughly.
Okay. So the 15,000 that Mr. Allen paid, that included Airbnb charges and the like?
Have no idea.
Okay.
Have no clue, because I'm seeing what they paid, and that could have been extra fees. That Airbnb charges could have been cleaning fees.
Are you responsible for receiving the income that's coming in if you're managing the
Yes.
property? Okay, tell me how much money in income did Mr. DeCandida receive from January and February?
I
for
have
that
no, I
booking?
mean, I don't even know why that's germane in this conversation. I don't have a clue as to why that would be germane. It's his property, it's his income.
Ma'am, I asked you a question.
Yes.
You're not going to answer the question?
I don't have those documents in front of me. My accountant takes care of all of the income, all the proceedings. I mean, we have 50 properties that we manage.
So are you-
So
you
I
telling me-
I wouldn't know exactly what income he had.
Okay, all right. No other questions, thank you.
All right, Ms. Erickson, I don't have anything else. Anything else you want to tell me?
No.
All right. Mr. DeCandido, is there anyone else you'd like to call or any other evidence you'd like to present to me today? Come on forward, you just got to get it on the record one way or the other.
I just want to plead for some leniency on this, given my age, the fact that I'm not really renting or actively managing these properties any longer, and that we have gone ahead and taken care of all the problems which we brought up on the previous hearing, and I'm still uncertain as to why the amount of rent is related to the length of stay of each tenant. I do not see a problem with continuing with your request the results of the previous hearing, and would like to continue that if possible, and I'm asking for leniency on the amount requested.
All right, thank you, sir. You can have a seat. All right, are there any members of the public that would like to provide comment in regard to case number CE-24-0023 for the property at 480 129th Avenue East? Any members of the public? All right, seeing none, we'll go ahead and close public comment. Mr. Trask, anything else you'd like to provide on this one?
Nothing further.
All right. Based upon the evidence presented to me today, including the body cam footage and the other evidence, it does indeed indicate that the respondent here had a short-term rental, as that term is defined under the city code, from February 3rd through February 27th, also in January, but I understand the city is not asking for a fine for those days. I'm not unsympathetic to the issue that this was a booking done through VRBO. However, the fact that it wasn't a 3-month booking is what I'm presented with. In other words, whether or not that rental specifically was a short-term rental. Even if you couldn't cancel it because of whatever contractual obligations you have with VRBO, the fact is that the zoning for this property and of R2 only allows for rentals that are at least, or does not allow for rental for less than a 3-month period. And certainly this rental, based upon the evidence presented to me, is less than that time. So I'm going to go ahead and impose a $250 a day fine from the 3rd of February through the 27th of February. And I'm also going to enter an order that the respondent shall cease all short-term rentals at this property in the order as well. All right, that concludes the hearing on that matter. Let's move on to 2022.3526 for the property at 590 Normandy Road. Is the city ready to proceed?
Yes, we're ready to proceed.
Go ahead, Ms. Trask.
I just want to start, first of all, this is on the property that's located at 590 Normandy Road. I just want to start off with, there's some information in your packet that was dealing with a request for a continuance by the property owner, Mr. Vestgarten, but he is here in the audience today, so we don't need to go over that request. That was the reason that it was in the packet. I'm going to go ahead and have Grace Mills be the city's witness, and Grace, you were sworn in earlier, correct?
I was, correct.
Okay. And if you could please explain what your occupation is, your job responsibilities here at the city.
I'm a code compliance officer for the city. I deal with violations of code, bringing them back into ordinances and permitting for the building department.
Okay. Are you familiar with this property at 590 Normandy Road?
I am.
Okay. Who owns this property?
Mr. Tove Vestgarten.
Okay. And how do you know that?
I will scroll down one moment. Page 38 of the packet shows the property appraiser. My first way of knowing is showing in the top left-hand corner. He is the ownership.
Okay, before we go through the rest of the packet, I want to ask you, is this particular case, is this a proactive case or was this complaint-driven?
This case was proactive.
Okay. And what was the violation that was found at this particular property?
For a shade structure / tiki structure was the violation.
Okay. And the shade structure that you're referring to, the actual code violation, though, is that they did not obtain a building permit to construct. Is that correct?
Correct. It was done without a permit.
Okay. When did this case first originate in the city?
Let me scroll down to that one moment. First documentation was September 13th, 2022 was our first courtesy notice.
All right. Well, that being September of 2022, we're now in February of 2024. Before we go through the documents themselves, what's the reason for the delay in getting this case before the special magistrate?
There was a few continuations that were requested that were moved, but prior to that, I'm not sure.
Okay, and the request for continuances, was that by the property owner?
It was, yes.
Okay. All right, so let's start with going through the documents themselves. You had mentioned earlier that you know that the property owner's name and address by way of the property appraiser's printouts. Is that pages 38 through 42?
Correct, yes.
Let me back up. 38 through 40, and then the tax collector is 41 and 42?
That's correct, yes.
Okay. Now, you had mentioned that the case started in September of 2022. Did you issue a courtesy notice of violation to the property owner at that time?
Courtesy notice of violation was issued September 13th, 2022 by Laura Robbie.
Okay, and who is she in relation to the city?
She was a previous code compliance officer.
Okay. And when this courtesy notice or courtesy notice of code violation was sent, did it specifically reference a code section that the property owner was in violation of?
Yes, the ordinance that it violated was section 8652 of when required. I can read all if needed. However, it goes over instances of when a permit is required within the city.
Okay. So this shade structure tiki hut, it does require a building permit in the city?
Correct.
If this was a tiki hut built by the Seminole Indians, would it still be required to have a building permit?
For the actual construction of it, I'm not sure.
Okay, but with regard to the setback issues, it requires a permit, correct?
Correct, thank you for bringing that up. Yes, for setback requirements, it would require the permitting process.
Okay. All right, so on page 43, is that the courtesy notice that was, actually 43 and 44, courtesy notice that was sent to the property owner?
Yes, that's correct.
Okay. If you could turn to page 45 and 46 and tell me what that is.
45 and 46 show the notice of code violation, which was sent certified mail, so it's our second letter that was sent to the property owner.
So what's the reason that another letter was sent?
The second letter is sent certified mail to ensure that they are actually aware of the violation, to give them a chance to bring it into compliance.
Did they bring it into compliance?
It has not been brought into compliance yet, no.
All right. So on the next page, 47, can you tell us what that is? Is that the green cards and letter that was sent?
Yes, 47 is the certified mail, just showing front and back of how it was filled out to be sent. And page 48 shows it returned, the green card returned.
And it was signed by somebody.
I couldn't tell you who, but yes.
Okay. All right. On page 49 of the packet, there is a statement of violation request for hearing. Is that something that you created?
That's correct, I created and mailed out.
Okay. And what was the date that you mailed that to the property owner?
February 16th of 2024.
Did you send that by regular mail and certified mail?
I did, correct.
Okay. And did you also issue an amended affidavit of service that is in the packet as pages 51 and 52?
I did, that's correct, on February 20th.
Okay. And when you filled out this amended affidavit of service, what does it actually tell us?
It is actually telling you the dates that on the 16th of February 2024, I sent the notice of hearing, certified and regular certified and regular mail. It also shows that I posted the property on the 16th of February with the document mentioned.
Okay. And did you issue a notice of hearing on February 16th as well?
I did, that's correct.
And is that set for today's hearing?
That is today, yes.
Okay. And is that pages 53, 54?
That's correct.
And the mailing is on pages 55 and 56?
Correct, yes.
Okay. Can you tell me what the photograph is on page 57?
Yes, let me zoom out one moment. That is reflecting the property that was posted February 16th, 2024.
So the camper is on the property where Mr. Veskarten lives?
That's correct.
Okay. And can you turn to page 58 and explain to us what we're looking at on page 58?
58 is showing that February 2nd, 2024, the structure's still at the property and has not been removed.
All right, this is a big picture. Can you explain to the special magistrate what we're talking about in this photograph?
Yes, this photograph shows the back of 590 Normandy where the boat is located. That's the parcel that is in question, and it's showing the unpermitted tiki hut that is still up.
Okay. So is it possible for the property owner to obtain a building permit where the tiki hut is currently located?
Currently, with the setbacks and the zone that it is in, it's not possible.
Okay. So to bring the property into compliance, what does the property owner need to do?
The structure would either have to be removed or a permit process would have to be approved where it could be located on his property if possible.
Okay. How much time do you think it would take, what would be a reasonable period of time to allow the property owner to take down the tiki hut?
The city finds 30 days to be reasonable.
Okay. And if the property is not brought into compliance in that 30 days, what is the city looking for fine-wise?
The city's asking $200 a day fine-wise.
Is there any life safety issues with this tiki hut the way it currently exists?
I don't believe at the moment.
Thank you. I have no other questions. I would tender into evidence the documents that start on page 38 all the way through 58. Ask that it be received.
All right, we'll go ahead and accept into evidence the document, or the agenda packet, pages 38 through 58 as exhibit number 1. All right, is there anyone here on behalf of the property owner, the respondent for 590 Normandy Road? All right, sir, come on up. Sir, what is your name?
Tove Westgarden.
All right, Mr. Vestgarden, as you saw in the previous hearing, this is your opportunity to ask Ms. Mills any questions about her testimony. I'm going to give you a full and complete opportunity to call your own witnesses, to tell me anything you want to tell me about this case in just a few minutes. However, this is your opportunity to ask her questions. Do you want to ask her any questions?
Yes, I do.
Go ahead.
Okay. First question I want to ask is on the code compliance that was sent out for the hearing, and in this packet on page number 44, it states that my violation is work being done at the property without the required building permits.
Yes, I'm there.
What does that mean?
The one required, it states that a permit needed to be required before putting the tiki up.
So what work was being done at the property when the code enforcement showed up?
A tiki hut being constructed.
That tiki hut is 4 years old, 5 years old.
I'm sorry?
That tiki hut is 5 years old. And you can look at the pictures from the code compliance officer when she was there, that all the thatch on the roof is old and gray. When they're built, they're green, and then over time, the palm leaves change color. And you can look at all the pictures she provided that they're not green, so it was not constructed.
I believe that was when either it was found constructed or found built.
It was built and it was there in place, but the code violation that I've been cited with is work being done at the property without the required building permit. And the work that was being done was the pavers.
I'm not sure what the question is.
So what I'm here for is a code violation, which is the pavers, which I've gotten a new permit for. So I'm in compliance with the work that was being done when she showed up.
I'm not sure what the question is.
So if I complied with the code violation by getting a permit, why would I be here at the hearing?
We are here for a tiki structure violation.
Which is not part of the violation. If you look at my hearing agenda, it says work being done. If you look at the one Mike has that's coming up next, it clearly says a structure. Mine doesn't say anything about a structure.
I'm sorry, about your tasks? Is that what the question was? I didn't quite hear.
The next part of the hearing is for Mike. He has a violation that's stated on.
Objection irrelevant.
And Mr. Vestgarden, again, I'm going to give you a full opportunity to share with me anything you want to share with me, but do you have any other questions for Ms. Mills?
Oh, yeah, I got a lot of questions for her. Let's move on from this. You said that the continuance was requested by me. How many continuances did I request for this hearing?
I'm not aware.
Did the city ever request any continuances?
I'm not aware.
You did say that a few continuances were done by the property owner
Yes.
and none by the city.
I did not say that in my statement, no.
So the cities did the first continuance, and that's when my attorney was ready for this, and I was ready for this. Now my attorney is out of town, and I'm
Yes.
cancel my trip, so I'm not properly prepared for this.
I mentioned multiple continuances as I have more than one from the property owner.
So if the tiki hut is of question, what code violation, what part of the code is the violation of a Seminole-built tiki hut?
For the Seminole built,
Yeah?
I'm not aware of where it is in the code. I could find it if you'd like.
Yes, please.
How would you advise?
When I read the code, it says that a Florida tribe tiki hut is exempt from a building permit.
And I appreciate that. You can argue that to me.
Yeah.
But this is, again, your opportunity
So
just to ask her
Now
questions.
my question is, what code did I violate?
Even if it was built from a Seminole tribe or such, it would still have to go through the permitting process to make sure that it's in the right setbacks, since your property is on water, that things are built to standards. It would still have to go through a permitting process just to verify where it's put.
I understand what you're saying. I understand zoning. what document can you give me that states what you just said?
Section 8652 of the city ordinances.
8652?
That's correct. It's on the violation paperwork as well.
Yeah, I saw the violation paperwork that you're citing. Where does it state in there that a Florida Seminole tribe cheeky hut is part of that?
I could read out the ordinance if you like. It doesn't specifically say that, as if it wouldn't specifically say that you would need a permit for other things. Covers the vast majority of it. I can read it if you'd like.
Yes, please.
8652, when required, a person, firm, or corporation shall not construct, enlarge, alter, repair, move, demolish, or change the occupancy of a building or structure, or erect or construct a sign, or install an altar fire extinguishing apparatus, elevators, engines, steam boiler, furnace, incinerator, or other heat-producing apparatuses, plumbing, mechanical, or electrical equipment, or any apparatuses, the installation of which is regulated by the land development regulations or other sections of the code until a permit has been issued by the building official. When the code of repair or modification does not exceed $500, does not result in a structural change, and does not require an inspection, a permit need not be issued by the building official. No permit is required for uncovered flat slabs of no greater than 50 square feet for work of strictly cosmetic nature, painting, wallpaper, carpeting, kitchen cabinets, etc., or roof work less than $100 in value.
Okay, so it didn't mention anything about the zoning permit needing to be done.
That section refers to when a permit is required.
Okay. And then I want to read from section 9442, where it says, building structure and facilities exempt from Florida Building Code. So since a cheeky hut is defined under this section that is exempt from a building permit, why is it a violation?
It was done without a permit, sir.
Okay, so when section 9442 states that a permit is not needed,
A permit's not needed for the actual design or building of the actual tiki hut. However, we do require a permit to make sure that it's put in the right place for zoning.
okay. They actually do go a step further and they say that what you need to do is get a floodplain development permit.
I'm not aware of any
building
of,
permit.
I don't work in planning and zoning, so I'm not aware of that.
No, but that's what it states in here, that you need a floodplain development permit, but not a building permit.
I'm sorry, what's the question?
So with that in mind, why would I need a building permit?
Section 8652 of the code ordinances.
Okay. Okay, in section 110, 427, again, it says no permit required. If I build something within that section, one of them being a playground for kids, would I need a permit?
You would have to ask the building department or the building official for that.
Okay. So apparently there's some questions here that the building department need to answer, but they're not here.
You have the opportunity to ask this witness any questions you want.
Okay. If a structure is not permanently attached to the ground, is that considered a temporary permit or a permanent where you need a permit?
I would advise asking the building department or planning and zoning department
Okay.
for that if you have any questions.
When a code compliance trespassed into my backyard to find the alleged violation, was that violation cited due to findings that's actually following the regulations, or is it just by they believe it was a violation?
If any work's being done or suspected of a stop work order needing to be placed, They will go onto the property to place that and get photos for the violation.
Okay. And the work being done was the brick paver, so that's really what the citation is about.
Oh, the citation's about the tiki hut structure.
Okay. So, no further questions.
Okay.
Mr. Trask, any redirect?
No redirect, thank you.
All right. Mr. Trask, do you have any other witnesses you plan to call today?
No other witness today.
All right, Mr. Vestgarden, this is the opportunity in the hearing where you can call any of your own witnesses. You can provide any argument to me. You can show me any documents you want to show me in defense of your case.
Okay, so now I just argue what I want to argue? Yeah.
That's correct.
So, for me, the biggest argument here is it's Seminole-built Cheeky Hut, and they have a federal law from 1990 where the federal government allowed the Native Americans of Florida tribe of Seminoles to build Cheeky Huts wherever they wanted to in the state of Florida. Then the federal government later modified it to say that they wanted it outside of the floodplain. And from what my research can gather is the floodplains of this region is 5 feet, and I believe that Madera Beach says it's 8 feet. And so if you're building a Cheeky Hut outside of the floodplain, you're following the federal agreement with the Native Americans, which is also in the building code, and Florida Building Code, and the Pinellas Building Code, and the City of Madera Beach Code. The floodplain, you got to apply for a permit through the city, and it states to obtain a floodplain development permit or approval, the applicant shall first file application in writing on a form furnished by the city. And I can't find it on the website. I can't find it anywhere. I went downstairs to ask for it, and they have no such thing as a form, application form for the floodplain. So if you follow the Muni Code, to build a Florida Tribe Cheeky Hut, you need to fill out the floodplain application, which the city of Madera Beach does not have. And then you can build a Cheeky Hut. I built a Cheeky Hut knowing that it was exempt from permits. I do want to file the floodplain application as the Muni Code states, but I'm not able to since the city can't provide it to me. The other thing is, this is a little side step, but my daughter uses it for a tree-house swing set and monkey bars. She's climbing around it, swinging around. When I saw the rule that a playground you can put up anywhere you want to, even in the setback areas. This is not permanently attached to the ground. It's just sitting on top of the pavers. It's a temporary structure, no foundation. It's a playground for my daughter. It's a place for shaded play for children. And if you want to look at all the different rules that the city of Madera Beach has, it will fit into several multiple brackets. So what I'm asking for is letting that Cheeky Hut stand as is, instead of having to move it to another part of the property, due to the city code section 110-427 stating that's allowable.
All right, sir, thank you. Mr. Trask, do you have questions for Mr. Vestgarden?
I have a few. And I'd remind you, sir, you're under oath. What Indian tribe built your tiki hut?
Seminole Tribes of Florida.
Okay. And did you have a written agreement with the Seminole Tribes of Florida?
I have a certificate from the tribal member.
Okay. And when was it built?
About 4 years ago.
All right. And did you go to the city and obtain any building permits for that structure at all?
No.
Okay. Did you obtain any permits from the city before you built that structure?
For the other parts of the area, but not the Cheeky Hut.
Okay. And under the tiki hut, you have a built-in kitchen, correct?
Correct.
Okay. And in that built-in kitchen, there's countertops, correct? Okay. Cabinetry?
No, but correct, yeah.
You have a barbecue or a stove?
Correct.
You have a refrigerator?
No.
Okay. What other amenities do you have underneath the tiki hut?
It's a countertop and a grill and an oven.
And an oven?
Yeah.
Okay. So you have electrical power out there to,
I do not. I do run an extension cord down there as needed, but I don't have power there.
okay. And the ovens then, are they run by electricity?
Wood.
I'm sorry?
Wood, firewood.
Firewood, okay.
Yeah.
So you have a fire underneath that
Yeah.
tiki hut?
Yeah.
Okay. And you have water service out there too, don't you?
I don't.
No?
No.
You don't have a sink out there?
There's a sink, but no water to it.
Okay. Have you, I know I asked you, and I don't want to repeat the question, I asked you whether or not you received a permit. Did you actually come to the city and say, I want to build this Seminole Tribe tiki hut? Do I need any building permits?
I did not.
Okay. All right. If you were to have to remove that structure, the tiki hut, how long would it take you to remove it?
If I have to remove it, I would actually move it to another part of the property. So I would have to get city approval to move it to the other part of the property outside of that setback.
Okay, how much time do you think that would take?
Probably 3 months.
And what would be the reason that it would take 3 months to move it?
At that time, it takes the city to give me a permit.
So if the city told you that they would not be issuing a permit, how much time would it take you to remove the structure?
Probably 45 days.
Okay. All right. Thank you. I don't have any other questions for you. Thank you.
All right, Mr. Vestgarden, is there anything else you want to tell me, any documents you want to give me, any other witnesses you want to call?
And there are a couple of more things. This is Florida House of Representatives. They signed a House bill, number 369, in April 14, 2021. And that one is accomplishing some of the questions that Mr. Trask had regarding countertops and so forth. It's actually spelled out in that House bill that you can have modern furniture, you can have countertops, all that stuff underneath a tribal tiki hut. So those questions have been lingering around for a while, but the governor signed a House bill to avoid all those questions. So that's in a House bill. The other thing is some friends of mine, they had a concrete bar with a tiki hut, not a tiki hut, but a tiki hut built, actually sitting on their dock.
Objection, relevance.
What are you trying to tell me about?
I have an
this
email
one?
from the city stating to them that you can keep your tiki hut on the dock as long as you put wheels on it. So with that in mind, I have wheels for mine. I can put wheels on it and follow that same pathway that the city already emailed out to state that it's acceptable.
All right, what else would you like to share with me?
That's it.
Okay. Mr. Trask, any follow-up questions based upon that additional information Mr. Vestgarden provided?
No, thank you.
All right, sir, do you have any other witnesses that you want to call?
I don't, but do you want a copy of that email?
Which email is that?
The ones from Holden saying that put wheels on it, it's okay.
No, I'm okay. I don't think I need that right now, but thank you.
Okay, thank
All
you.
right, at this point in the hearing, we'll invite any members of the public who have any knowledge or directly affected by this code proceeding at 590 Normandy Drive. Any members of the public that want to come forward? Okay, seeing none, we'll go ahead and close public comment. Mr. Trask, can you address some of the legal points that Mr. Vestgarden raised, and specifically the code provisions and why this particular structure that was built would require some kind of submission to the city?
First of all, the reference to the tiki hut, or actually, they refer to it in the statute as a cheeky hut, C-H-I-C-K-I-E-E hut. That is an exception under the Florida Building Code that specifically provides that a building permit is not necessary for the construction of that Seminole Tribe built or Muskogee Indian Tribe built structures. He's obviously testified today, and we have nothing to refute that it was built by the Seminole Tribe. But that only has to do with the construction of the structure itself. It doesn't have anything to do with the location of the structure. That's really what the issue is today. As for the House Bill 369, I'm not familiar with that, but my questioning relative to the countertops and the stove and the barbecue grill and the sink was just to establish the fact that it's not a playground. It is a place located underneath that structure that people will use for entertainment of some sort. So I really can't answer the direction on House Bill 369, but that's not where I was going with those questions. As to Section 110-427, I don't have that in front of me, so I don't know the answer to that question relative to floodplain requirement. But floodplain approval is necessary, or a review of it at least, in every building permit application that the city processes. And so that obviously would be in addition to the setback review that would be done by the planning department. So hopefully I've answered the questions relative to the legal things that was very good. You don't normally have a pro se person speaking, quoting the law, but and just in summary also, I'd like to say that the city would request that you find the property in violation, give Mr. Vestgarten the 45 days necessary to remove the structure or obtain the appropriate building permit, or the wheel situation, if that is appropriate, I'm not sure. And should he fail to do that within 45 days, that a $200 a day fine would be established. We were going to be requesting 30 days, but he has said that he thinks it'll take 45, so I think that that is fair and appropriate.
So, Mr. Trask, in order to get a permit, it sounds like he needs to apply because this may be within a setback,
Correct.
and it may also be within a floodplain.
Correct.
And even though it's a Seminole tribe-built Cheeky Hut, it would still require the city to review this structure so that it's not built within a floodplain or built within the setback.
Correct.
If it's planned or presently built within the setback, is this something where the owner would have to apply for a variance, after the fact variance or something like that, or?
I'm not sure whether or not a variance would be appropriate, but obviously he has the right to file an application for you to consider.
And this is more to the timing aspect of all of this, is if it would otherwise be permitted, and I'm not asking you to opine whether it would or would not, if it would otherwise be permitted, but he would have to go through a variance process, it may result in him having to go through a variance process, I guess what I'm saying.
That's an option, I would think.
Okay.
Yep.
All right. Thank you, Mr. Trask. Okay, based upon everything that I found, Mr. Vestgarten, that was a pretty good legal argument. I followed you all the way through on everything like that. The city's position is not that you needed a building permit for the physical construction of the Cheeky Hut itself. It's that you needed to come in and apply so that the location of the Cheeky Hut, where it was placed on your property, is permitted by both the setbacks, their rear and side yard setbacks, and there's also this floodplain requirement. And so the corrective action in this case is one of two things: either apply for an after-the-fact permit, which you can apply just as you're applying for a building permit. I assure you that the city is well aware that you may be coming in and doing this. The question for the city is whether or not where you located the Cheeky Hut on the property is permitted by the Code of Ordinances. It's not whether or not you can build it or need a permit for the building. It's whether or not its location complies with the city code. And so what I'm going to do is I'm going to give you 90 days to come into compliance. So you've got time to talk with the city to apply what you need to apply. If it is going to be in a setback, I don't know whether the city staff would approve it being in that setback or not, whether it's in the floodplain. I don't know whether they'd approve that or not. But there is another proceeding that you can come before me where you ask for a variance. In other words, you ask for a deviation from either the setback requirements or the floodplain requirements. Again, I'm not considering that today. As I said in my introduction, I have no power as the code enforcement special magistrate to grant you a building permit, a variance, or special exception of any kind, but I know that may be available. So I'm going to give you 90 days and then a $100 a day fine after that. You can either remove it, physically move it or apply for a building permit. I'll also say this, I retain jurisdiction of these so that if you get 60 days into this process or 45 days into this process, and there's some issue that you're encountering, you can ask the city to notice this and come before me. I'm here basically every 30 days. And if you need an extension of time because you don't feel that there's the appropriate application or something like that, or you want to show up with your attorney and make an argument, whatever you want to do, I'm here every 30 days. You just need to put the city on notice that you want to have something heard so it can be noticed to the public properly, and I'll hear what you want me to hear, okay? All right, sir, that ends the hearing on 2022-.3526. We'll now move on to 2022.3537 for 544 Johns Pass. Is the city ready to proceed?
Yes, we are.
Go ahead, Mr. Trask.
So the city is going to call Grace Mills on this case as well. Grace, if you could then again state your occupation and your responsibilities here at the city.
Grace Mills, Code Compliance Officer. I deal with violations for codes, bringing them into compliance, and also permitting in the building department.
Okay, are you familiar with the property at 544 Johns Pass Avenue?
I am.
Okay, is this a code case that was a proactive case, or was this a complaint?
This was complaint-driven.
Okay, and what was the complaint that the city received?
Let me scroll to show on the screen so everyone can see. Let's see here. We received a code complaint form in October 14th of 2022 from a Michelle Helms, and it was a complaint of an eyesore and view issues building Tiki Hut.
Okay, and the date of that complaint?
That was October 14th of 2022.
All right. Did you go out and inspect this property, or did someone else do that?
Someone else has.
Okay. So let's go back to the beginning of the packet and get a little bit more information about the property. This property at 544 Johns Pass Avenue is owned by whom?
Michael J. Otten.
And you know that because of the printout from the property appraiser's office?
That's correct.
Okay, and in the packet, if you could look at page 59 through 61, is that the printout that for this property?
Yes, those multiple pages are the printout from the property appraiser of the property.
Okay. And did you also make a printout from the tax collector's office?
I did.
And what pages are those?
That is reflected on 62 through 63.
And what do they reflect as to ownership?
That shows the real estate account ownership of Michael J. Otten at the property address.
Okay, now, we started out this conversation with a complaint from a neighbor at 546 Johns Pass Avenue. That complaint came in, it's on a written form that the city created?
That's correct. Those are our code complaint forms.
Is this something that is online, or someone actually have to come into the city hall to fill it out?
It's online, and we also have them in the building department. If people come in, they're readily available.
All right. So when this complaint was filed, was it received and acknowledged by somebody at the city?
Yes, it was received October 14th, 2022. The time reflecting is 8:49 a.m. by Lisa Sherman.
And who is she?
She works in our planning and zoning department. At the time, I believe she was at the front desk in her position.
All right. If you could turn to page 65, this photograph. Who took this photograph?
That photograph was from the neighbor at the 546 Johns Pass Avenue of their view.
So the neighbor that complained provided this photograph?
That's correct.
Okay. And down below the photograph, it has the word denied app 7685. Can you explain to us what that means?
That was an application to put the Tiki Hut in, and I believe they had just tied the photo for the notes, so it was under the photograph, but they did put an application in, which is the 7685.
Okay. When did someone from the city go out to the property to inspect it?
I'm not aware of that.
Okay. Do you know whether or not a permit application was filed or filed with the city to obtain an approval to build the structure that is being built at 544 Johns Pass Avenue?
Yes, we did receive a building application for the said Tiki Hut.
Okay, if you could turn to page 66 in the packet. Is this the building permit application you're referring to?
That is the front page of the permit application here, yes.
Okay, can you tell us what pages consists of this application?
It's going to start with 66. A revision actually starts at 74 of this same application, and it's going to go all the way down to 81, which is our final notes.
Okay, so let's go through this page by page then.
Yes, let me get back up.
So starting at page 66.
Yes, page 66.
So this application would have been submitted by the homeowner, correct?
Either the homeowner or the contractor typically.
Okay, so is the homeowner listed there and is the contractor listed on this building permit application?
Yes, they're both listed.
Okay. Down below at the very bottom of page 66, in the left-hand corner, it has a red stamp, City of Madeira Beach Planning and Zoning Site Review.
Correct.
Okay, there is some handwriting in there. Can you explain what all that is?
It looks on the left-hand side that it is marked as not acceptable by someone's initials and the date that it was marked.
Okay. Would that have been Al Carrier?
I believe so, yes.
And who is he in relation to the city?
He's contracted to do reviews of our permits.
Is he an engineer?
I believe so, yes.
Okay. Over to the right, there is another stamp. City of Madeira Beach Building Department, code review for code compliance. And then off to the right, it's got handwritten the word denied.
Yes.
Okay. Was the word denied written by someone on city staff?
It would have been in our department, yes.
Okay. So this building permit, it appears on page 67 to be for a description of work consisting of a 12 by 12 leg set, 14 by 14 roof set, native tiki structure.
That's correct.
Okay. Was this first permit denied as a result of the size of the structure being built?
That's correct.
Okay. If you could turn to page 74 then. Was there an attempt to amend the building permit application to make the structure smaller?
Yes, there was a revision request put in to actually revise the original 8 by 14 blueprint down to an 8 by 10 to keep it into compliance.
Okay. And along with that revision request, it looks like the next page there is a survey of some sort. You see that, page 75?
Correct, yes.
Does that reflect where the structure is going to be located?
It does show in the rear of the yard points of where it would be located.
Those are the little blue boxes where the feet or the posts would be?
Correct, yes.
Okay. And the next page, 76?
The next page, 76, is an in-person view. The blue circles, there's actually blue tape there marking where I believe the leg sets would be proposed to be.
And was this photograph provided by the property owner?
I am not aware of that.
Okay. So if we could turn to page 77 then,
Yes.
what is this document telling us?
This is a revision that went with the original permit. So I believe there was a resubmittal to correct review comments.
And when was that done?
That was April 5th, 2022.
Okay. So the rest of the pages through page 80 are just continuations of either surveys or portions of the permit application, correct?
That's correct.
All right. If you could turn to page 81 then. So what is this document?
This is from our system that we use called Munis. It is a printout of the application text that have been going on with the permit. And in this, it reflects notes that we have sent to either the property owner or internal.
Okay. In the middle of that page, it looks like it's May 16th, 2022.
Yes.
Can you read that section out loud?
AC denied permit on, let's see, May 12th, 2022, comments in plan review tab, gave to BS 51622 for filing. Underneath that, Christina, thank you for submitting revised documentation in response to city comments dated April 26, 2022. Unfortunately, I failed to recognize during the first review that the property is located on the water. Per our phone conversation this afternoon, the permit will be denied pursuant of the following codes. Per City Code of Ordinances, Chapter 110, Section 110-472, parentheses 2, for lots on the water in R1 single-family residential zones, accessory structures may be located in side or rear yards. If the accessory structure is located in a side yard, a minimum of 2.5-foot side setback must be provided. If the accessory structure is located in the rear yard, the same rear setback as required for principal structures must be provided. Per City Code of Ordinances, Chapter 110, Section 110-181, parentheses 2, the minimum rear yard setback for waterfront lots is 30 feet. It goes on to say, BD emailed C an email address. Would you like me to spell it out?
No, that's not necessary.
On 5/10/2022, as discussed, codes pertaining to tiki huts do not exist. Reviewers are directed to apply to what fits best for category. Thus, in this situation, accessory structure rules apply. If you have any questions, please contact Jenny Rowan, Senior Planner, and our phone number.
Okay. So the permit obviously was denied according to those notes in May of 2022.
Correct.
Why was there a courtesy notice of code violation issued on October 20th, 2022, some 5 months later?
I can't speak for that.
Okay. When the courtesy notice of code violation was mailed, it was mailed to the property owner, correct?
That's correct.
And what was the cited code section that was in violation?
8652, which is R1 required. It was also added Section 110-472, which is an R1 single-family residential zone for the zone that the property's located in.
And the violation detail on that courtesy notice?
An accessory structure has been built at the property without the required building permits. Either the property owner and/or licensed contractor will need to apply for and obtain an after-the-fact building permit to comply. If a permit cannot be obtained, the structure must be removed.
Okay. Was the structure removed as a result of that letter?
Not as of yet, no.
Okay, in the next couple of pages, that letter is obviously 3 pages long through page 84 in the packet. Did these property owners, even though the permit was denied, go ahead and build the structure anyhow?
It was completed, yes.
Okay. Was there a notice of code violation issued in November of 2022?
There was, November 21st, 2022, to the property address and owner.
Same code violation, 8652?
Yes, and the 110-472 for the R1.
Okay, this letter says it was signed by Frank DeSantis, CBO. Who is that?
And that is our building official.
Okay. Was this letter sent by regular and certified mail?
Yes, correct.
Okay. And does the packet reflect the certified mail?
Yes, page 88, you'll see the front and back of the certified mail.
Well, that's for Mr. Vesgarten. That's for the prior case.
Oh.
Can you turn to page 89?
I'm sorry, yes. 89 reflects the certified mail that was sent out, and it also was returned unclaimed.
Okay. Now, that was in 2022. When did you actually issue the notice of violation for today's hearing?
February 16th, 2024.
Okay. Did you issue a statement of violation and request for hearing then?
I did, yes.
Is that on page 93 and 94?
Yes.
And that cites that the property owner needs to get a building permit for that structure, accessory structure?
That's correct.
And did you issue a notice of hearing for today's hearing?
I did.
And is that on pages 90 and 91?
Yes.
And did you send both the notice of hearing and that statement of violation to the property owner by regular and certified mail?
I did, correct.
And is that reflected in the affidavit of services on page 95 and 96 of the packet?
It is.
Okay. And what is page 97 and 98?
Pages 97 and 98 are the front and back of certified mailing for the magistrate documents.
Okay. If you could turn to the next page, which is a photograph, can you explain what that is?
Yes. That page is the property that was posted February 16th, 2024.
Okay. And it's the property where the blue Jeep is?
Yes.
Okay. And then the last document in the packet,
That is the most recent photo of February 2nd, 2024, and that reflects that the tiki is still standing in the rear premises of the property.
okay, so in this photograph, it's that, obviously, it's that tiki hut in the middle of the photograph, correct?
Correct, yes.
Okay. And that looks significantly different than when the property was first sighted, correct?
Correct.
Okay. In fact, when the property was first sighted, it was just the wooden frame structure
Correct, yes.
on page 65 of the packet.
Correct.
Okay. All right, I don't have, so as of today, this photograph that we just discussed on February 2nd, this is the way the property looks as of February 2nd.
As of February 2nd, that is how the property looks, yes.
Okay. Are you aware whether or not the tiki hut has been removed?
Not as, since February 2nd.
Okay. All right, thank you. I have no other questions for Grace. I would tender in the evidence documents, pages 59 through whatever that last page is. Can't read. It would be 100, except for page 89 or 88, which is a mailing for the prior case that was inadvertently in the packet. So 59 through 100 minus page 88.
All right, Mr. Trask, go ahead and accept into evidence as exhibit number 1, the agenda packet, pages 59 through 100, after removing page 88, which was put in there inadvertently.
Thank you.
Ms. Mills, I just want to make sure I've got a full understanding of the issue here. The owner applied for a building permit, and at the time staff was reviewing it, the determination was made that it could not go where it was being proposed because it was deemed to be an accessory structure in the rear yard and therefore had to be set back at least 30 feet from the waterfront?
That is correct.
All right. Okay, is anyone here on behalf of the landowner? Respondent? Okay, come on up. All right, what is your name?
Hi. Christina Juvenko.
All right, and spell your first and last name for me, please.
Christina, last name Giovenco.
All right. Ma'am, as you saw earlier, this is your opportunity to ask Ms. Mills questions based upon what she testified to. You're going to have a full and complete opportunity in just a minute to tell me anything directly you want to tell me, but this is your opportunity to ask her any questions you want to ask her.
Okay. I'm going to kind of refer to some of my notes.
Okay.
We did, as you showed us, we applied for a permit, and then after we paid for engineered drawings and showed them everything where it was going to go, I got the email that you put up that said, oh, I didn't realize you lived on the water. Well, most people on Madeira Beach live on the water, so that was a little frustrating because we had done the due diligence that we thought we were supposed to do. So after we received that email, obviously my first call was to the city, to the planning department, and say, hey, the reason we did this was because there's 26 plus other tikis around, which I have pictures of here.
Question, ma'am. Questions.
Yes.
Questions.
I'm sorry. So I was told, if nobody complains, just build it. So that's why we built it. So my question to you is, over the last year, I have been present for city commissioners meetings, planning meetings. I'm sure you can see a lot of the evidence showing that, as you rightly just said, it doesn't really address cheeky huts in the code specifically, and trying to get the code of setback changed. So what are you guys doing to change those at this time?
Unfortunately, I'm not on the Board of Commissioners, so I do not have any knowledge on that.
Well, it would be great to have somebody here that is familiar because this is a code violation issue, right? Like, and setbacks are a huge thing. Most of our houses are 30 feet, like at the, there's no shade structure that anyone can have on the water because right now the setbacks are unrealistic. So that's what I'm asking you is like, are you guys working together to get those codes changed, or what is happening with the city right now?
I would definitely probably reach out to the city and the Board of Commissioners to see where things are at for that, or to the building department if you'd like.
Okay. Has anyone been on our property to view? Because you were saying that there hasn't been anybody, has anyone come to our property to actually view the?
Has anyone come to your property?
Yes.
I'm not aware.
Okay. That's all the questions I have for you.
I have no redirect, and I have no additional witnesses.
All right, thank you, Mr. Trask. Ms. Mills, I just want to make sure that it's in the record today. Your opinion is that this, and this I think is an actual tiki hut, is properly considered an accessory structure under the applicable code?
Yes.
And so because it's deemed an accessory structure, the only way it could be approved is if the owner were to get a variance that would allow it to go into that 30-foot setback from the waterfront, correct?
That's a possibility.
Okay. But it's your opinion in this code enforcement proceeding that it's in the rear yard as opposed to the side yard, correct?
Correct, yes.
Okay. All righty. Okay, ma'am, this is your opportunity to present to me any and all evidence that you'd like to present. You can call other witnesses. You can tell me anything you want to tell me. You can show me any documents you want to show me.
Awesome. If you wouldn't mind, I'm just going to look at my phone because I have a couple of things written down. So
Take your
I'm going
time.
to start from the beginning. So in mid-2022, we explored the option of a native cheeky hut after seeing more than 25 plus similar structures in our immediate waterfront area. After submitting all the paperwork that was requested of us, we paid for an engineered drawings for the city that the city requested. Then after they realized we were on the water, we were told that the setback of 30 feet would not permit any kind of permanent structure. And so when we phoned the Madeira Beach Planning Department, we were told verbally, obviously there's no evidence of that, but we were told verbally, as long as no one complains, just build it. And that is what we did. In October of 2022, as the cheeky hut was being thatched, our neighbor at 546 Johns Pass Avenue got into a verbal confrontation with my husband about the tiki blocking her view. Subsequently, came down and made a formal complaint, as you showed on your documents. In 2023, we have participated in multiple Board of Commissioners meetings and Planning Commissioners meetings to facilitate change for our community, which focused on providing necessary and much-needed shade for our rear backyards. Often, many of them are west-facing. We get really, really strong sun in the afternoons. I did a change.org campaign. We had over 200 signatures from our immediate Madeira Beach community. Mr. Trax, you've been present for a lot of those meetings. So everyone was in agreement that 30-foot setbacks, as they sit right now for waterfront properties, need to be addressed and reevaluated. So that's why it's now 2024 and we're still here. We haven't not been in compliance on purpose. We've been trying to invoke change, not just for ourselves, but for everybody in the community. Beyond it being a community concern for shade, this is personal to me because I do have a disability that is degenerative and prevents me from walking to the beach, which is the whole reason we live here in Madeira Beach. We have lived in our home for 11 years, and over the past 12 months, my quality of life has improved greatly after being able to enjoy our backyard under our cheeky. We worked with Mayor Jim Rostek from the very beginning. Once we got notices, and the city manager, Robin Gomez, we came right down to his office. We had those meetings with him. They all, agreed with us that we need to change those codes. Code violation relates to a permanent structure. This is not permanent. This has removable brackets, which I can show you, and you can have this packet. So it makes it a non-permanent structure. Similar to what was offered to our other neighbor on Normandy with wheels, there is an email that clearly states if you put it on wheels, we'll reassess it. It makes our cheeky non-permanent. Our cheeky is also a native structure. We have the certificate from the Seminole tribe, which I can submit to you as well, showing that it was a native-built structure. There is no power. We have no electrical. It is just a shade structure. So we are open to having a conversation about how to make this work for us.
Okay, I understand all of your arguments. Is there any documents you'd like me to see? If so, please show them to Mr. Trask first.
Okay.
Okay, I'm going to address a couple of these different things. I obviously have no objection to this partial email. It doesn't state the beginning of it unless it's on the other side. Hang on, let me just check. Okay, the whole email is there. I have no objection to the email coming into evidence. I have no objection to the base post information coming in, or the wood base photographs coming in, or the certificate coming in, but I would object to the photographs of all these other cheeky huts as being not relevant to our particular case.
All right, Mr. Trask, let me take a look. All right, ma'am, I've reviewed everything that you've provided. Let me ask you about these pictures that Mr. Trask has objected to. Is it your contention that all of these pictures are of some kind of accessory structure in the backyard of properties in Madeira Beach?
Correct.
And who took these photos?
I did.
And they're all within the city?
They're all within the city of Madeira Beach. Correct.
All right, ma'am, do you want me to include all this in the record?
Yes, please.
Okay, what I'll do is first let me mark as Exhibit number 2, the email exchange. I'm going to go ahead and mark as exhibit number 3, this package that you have submitted. I'll overrule the objections of Mr. Trask and let this in, but I'll note for the record that the city has no objection to the last 3 pages, but I'm allowing in the first several pages, everything up through the last 3 pages over the objection of the city. All right, ma'am, what else would you like to tell me?
I just want to, for on the record, just to know that we have been working diligently with the city to make sure that we can, right now it's there's no like definition of a cheeky. It's included as an accessory structure, and we need more definition, and we need to taking FEMA guidelines into consideration, which I know are important, but we need to really look at them and see if we can provide shade structure for those of us that live on the water that is less than 30 feet, because it's not realistic. And that's what we've been doing for the last 12 months. So,
All right, well, thank you, ma'am.
Thank you for your time.
I appreciate that. All right, is there anyone else you want to call, ma'am, as a witness before you go back to your chair? Anybody else you want to call? Okay, and for the record, Ms. Giovinco said that they do not want to call any further witnesses. All right, this is the point in the hearing where I will accept public comment. Are there any members of the public that would like to comment on case number 2022.3537 at 544 Johns Pass Avenue? All right, ma'am, I think you came in late, so we need to get you sworn in. Mr. Trask, can you go ahead and swear in the witness?
You swear that the testimony about to give is going to be the truth, the whole truth, and nothing but the truth?
Yes,
All right, thank you.
Ma'am, what is your full name?
Michelle Helms,
And ma'am, just go ahead and give us your address for the record, too.
546 Johns Pass Avenue.
Go ahead and tell me what you'd like to share with me, ma'am.
So I'm the one that put in the complaint. That was back around 8 o'clock, 8:30 in the morning back on October of 22. I came down to City Hall, requested to see somebody in reference to code compliance. They had me fill out the form, and basically they were erecting this Taj Mahal next door. My problem is that as a person that went through remodeling, we just had completed all of our remodeling through our house on Johns Pass. We actually had a porch that was approved by the city through our remodeling and everything. And when it got done and said, and we were all to the end of the point of actually getting our final, the porch itself on the back was told that we had to bring it back in because it was not 30 feet from the backyard in. So we actually had to remove the porch on our house. So it was basically taken down because it wasn't 30 feet from the back level, which I understand is not anybody else's problem, but I understand the shade, as Christina's saying. But at the same point, when I'm looking out, and I know we're only supposed to look at our view out the back door, having a raised deck 3-4 feet because of her disability, and they put in a pool and they raised it. I have no problem with any of that. But now you're putting another deck with the structure that you see above, and we no longer can even have the porch that was only 1.5 feet out from 30 feet attached to our house. So if we're going to allow this, that's fine. But if I came to the city and got everything approved for remodeling, and you then at the end said, sorry, you can't do this, it's not allowed, it's 30 feet. It was a Linda Portal thing back then. But here we are with a shade structure that is not allowed 30 feet from the back, and it's clearly very, very large. And I would think a cheeky hut would be smaller. My daughter-in-law actually came down to the city about 3 years ago and applied for a cheeky hut permit through Linda Portal to get a variance to allow her to build one because she has skin cancer. So we all have cancers, we all have disabilities. I get it. She was denied. They didn't call and then go, oh, well, they said just build it, don't worry about it. If somebody comes by, you'll have to remove it. We don't play that game. If I'm gonna do something, I'm gonna do it properly, or otherwise I'm not gonna do it. Or I get told to take it down, and I take it down. Here we are 2 years later, and we're trying to change the law or trying to change the amendment or the variances or whatever you all have out there to apply this to something that they obviously just went ahead and built because somebody from the city said, go ahead and do it. Well, that doesn't normally come out right. I mean, I don't know what y'all look at, but for me, you know, I just think if you're denied something in May or June or whatever time frame it was, why would you turn around in October and build it anyways? So to me, I agree that if you do come up with a structure or a sizing or a height restriction from the base up, if your base is down at everybody else's level, or is your base 3 feet higher because you built a deck from that point up, what are the requirements? And if you're going to do it, that's fine. But I don't think that if you went ahead and built a structure because somebody said just go ahead and do it, that it's okay. That, well, we'll wait for you to change the permit or the rules, or other people did it, so therefore if other people did it, it's okay that I do it. Well, that's not right. I mean, it would have been one thing, build a smaller one, put it on the other side, do whatever, but, you know, it's bigger than my bedroom if you look at it. You know, it's a very large facility, you know, what they built. My thing is, you didn't get approval to do it, but you went ahead and did it because someone said, go ahead and do it. I don't know who in the city would give somebody that authorization over the phone, but I'm sure you have, you know, recorded phone conversations. But it doesn't make sense to me that would be appropriate. It just took too long for the city to, in my opinion, to come up with what's going down. I mean, we have been here. You all have actually postponed them a couple times. They've been out of the city, you know, on vacation or whatever in the last couple of years, along with just like last month, they were out of town. I mean, it just keeps getting prolonged. And I think that just is difficult for me when, you know, we responded very quickly when you all wanted ours to be removed. Okay?
Thank you for your time, ma'am.
Thank
I
you.
appreciate your
Sorry.
comments.
You're
I understand what you're saying. All right, Mr. Trask, anything else? And I just want to make sure, maybe I didn't hear it, and you're welcome to recall Ms. Mills if you think it's necessary. What's the city looking for in the way of compliance, timelines, and everything like that on this one?
I think it would be appropriate to have the same time frame as that you gave Mr. Vestgarten. It's the same issue and the same daily fine. It's the same issue, so I think the city would be satisfied with that. Yeah.
All right. Mr. Trask, I want to give you an opportunity to respond legally to any of the arguments that were there, and also I'll ask you the same question I asked Ms. Mills in regard to the city's interpretation in the Muni printout that's on page 81. Is there anything you'd like to share with me legally? Is there anything you want to tell me? I don't see specifically accessory structures listed. I see accessory building is defined in section 82.2, and this certainly appears that a cheeky hut would meet that definition. But is there anything you want to tell me in a legal argument? I certainly see where the 30-foot setback would apply. It seems to me this is in the rear yard, but anything you want to make any kind of legal argument in regard to what either Ms. Mills testified to or what's on page 81?
I don't have anything additional to add. Those are the citations to the code section that the planning department determined were appropriate. It would be no different than Mr. Vestgarten's situation that you heard earlier today. It is an accessory structure. It is in the setback. It was done without a building permit.
And I want to give you an opportunity, too, to make a record. I know I overruled your objection on the photographs. I understand your objection to relevancy because they may have variances. We don't know. We don't know what code they were permitted under. But is there anything you want to do for the record to set forth your objection beyond just what you've already stated?
So I believe it's irrelevant. It has nothing to do with this particular property. Those are separate properties. They could have been approved prior to the code provisions that were adopted relative to accessory structures. Therefore, they could be grandfathered. We don't have any specific measurements as to where they are in the backyard. You know, in addition to that, we don't know whether or not variances were actually provided for those properties sometime in the past. And it may be that there was a permit for a particular structure and it was modified that we were not aware of.
All right, thank you, Ms. Trask. I understand your objection. I'm still going to overrule it and allow it into the record. All right, based upon the evidence that's been provided, there has been no permit. It would appear a permit is required. It also appear that this accessory structure was built into the rear setback. I don't see any evidence of a variance that would allow it to be constructed where it was. I'm going to go ahead and go along with what I did for the prior owner, 90 days and then a $100 a day fine. Ms. Giovinco, I'll say the same thing I said to your neighbor there. If, work with the city on this, you can always come back and ask to be before me again. If I don't have any idea what the city commission is going to do or not do, obviously, if the ordinance changes or something like that, or if there's some action, then you can bring it before the city and ask to come in front of me again. The same thing goes for the cure, whatever's been stated on the record here as to what you can do to cure this violation will apply. If for whatever reason we get to that end of that 90 days or getting close to that 90 days, I would encourage you to ask the city to set a hearing and come before me again. But I'm going to go ahead and rule the same way, and I'll get an order out on that. All right, Mr. Trask, is there anything else for me today?
Nothing else, other than we should have had the air conditioning on.
That's okay, Mr. Trask, thank you. All right, that concludes today's hearings.
Thank you.